appeal in the matter of R and the Secretary of State of the Home Department.
Good morning, my lords, my lady. As the court will have noticed, I am not Sir James Eady, Queen's Counsel. Could I pass on his apologies? He wasn't available today, and as the matter had been expedited, and it wasn't possible to find a date when all counsel could attend, the matter was fixed for today despite his unavailability. So I appear with Mr Andrew Deakin on behalf of the Secretary of State, the appellant, and Mr Dan Squires appears with Miss Aisha Christie on behalf of the respondent.
Yes.
Could I just mention at the outset, at the time that the bundles were prepared, an application for anonymity had been made, but it hadn't yet been determined. As I know Lady Justice Whipple will be aware, such an order was made, because it was made by her.
I think I have determined it, yes.
Yeah, I don't think it appears in the bundles. We've asked for a copy to be sent electronically, and we've got hard copies. But we're all aware that there is an anonymity order in place, and we will obviously refer to the respondent as a D4 throughout these proceedings.
Thank you very much.
As to other matters of housekeeping, could I just check that all members of the court have the documents that we hope they will have? So in terms of bundles, there is a core bundle which runs to 165 pages.
I don't do bundles, I'm afraid, Ms. Giovanetti. Core bundle has 163 pages electronically.
2 were added quite late to the hard copy.
Yes, we will try and find out which 2 pages are missing and make sure that my lord has them electronically. I'm so sorry about that.
It's the grounds of appeal, I suspect, which were originally put in as something A and B, 40 A and B, and then were moved to the last 2 pages. Have I got that right?
I think so. Yes, you have. And I'm so sorry that there were some problems with the bundles. I had hoped that by today they would all be in order, and I hope apart from those 2 pages missing from the electronic bundles, that the others will be in order.
I haven't got a 40 A and B, but I have got 2 pages. No, I haven't.
Can you access your emails there?
Yes?
It was it's on an email which was sent.
It was on an email?
Several times.
Okay, I'm sorry. I claim to have been a little busy. I don't use it.
I'm going to ask that those be sent through now immediately, and I don't know if I...
Oh, well, if it goes to my clerk, it'll come straight to me. But when was it sent?
Day last week.
Thursday?
Thursday last week, I'm told.
Right. Latest core bundle with apologies. New. There we are, 165. Thank you very much.
And there's also a supplementary bundle, which I hope runs to 161 pages, both electronically and in hard copy.
Yep.
And an authorities bundle, which has 20 tabs, 10 of which are legislative material and 10 are judicial documents.
Yep.
Thank you very much. So, as the court will be aware, this is the Secretary of State's appeal in the order of Mr Justice Chamberlain, made on the 30th of July 2021. Following an expedited timetable for the judicial review. You have a copy of that order. I wasn't going to turn it up now, but it's in the core bundle. It's document 6, pages 58 and 59. Permission to appeal was granted on the 8th of October 2021. You have that at page 26 of the core bundle. And it was granted, you will have seen if you've had a chance to look at the order, not on the basis that the grounds were arguable, so not an auspicious start from our perspective, but on the basis of the public importance of the issues. And these are issues which impact on a significant number of other cases, including in particular other cases where deprivation of citizenship orders have been made for reasons of national security in respect of individuals having been assessed to have travelled abroad to join terrorist organisations such as Islamic State. So the appeal turns on a point of statutory construction, and what I was proposing to do was take you briefly to the relevant legislative provisions just to give you an overview of them, then very briefly to the facts and procedural background before turning to our submissions. If that's satisfactory, we'll start with the authorities bundle, if I may.
Yeah.
So the key provisions are sections 40, 40A and 41 of the British Nationality Act 1981 as amended. You have section...
Is the 71 Act that we're referred to in force or not?
Yes, it is. That's the Immigration Act 1971, and it's not at issue in these proceedings, but it's just another example of a statute which contains an enabling power under which regulations have been made which allow for
Right,
deemed
but the
notice.
enabling power is still in force in the 71 Act.
But not for the purposes
Not
of...
for the purposes of the
Yes,
1981
but the...
Act.
Yes.
The 81 Act was a successor to, was there a 48 Act?
Yes, which itself was a successor to, I think, a 1914
And
Act.
is the power that we're looking at of deprivation of citizenship a new power that was introduced in 81, or has it existed historically before that?
No, it's existed historically. The procedures for appeal and review have changed very significantly over the years. I think the power has always been there.
Yeah.
Only applied to people who naturalised.
Naturalised.
Yes, until 1981 it only applied to people who had naturalised as British citizens, but there has been a power to...
So born here, is that born British citizens, you couldn't be deprived of your citizenship until 1981?
Yeah, citizens by birth, that's right.
Thank you.
Couldn't be deprived until 1981. I'm grateful to Mr. Squires. So
But you can now.
you can now...
And is this person D4 born here?
She was, yes. You can now, subject to the protections of the statelessness provisions, which mean that a person cannot be deprived of British citizenship if the citizenship status, if deprivation of citizenship would leave them stateless, save in narrow and constrained circumstances, and that power was enlarged by amendment.
So does that mean that you can leave them stateless in narrow circumstances?
In accordance with subsection 4A, which I was going to go to, but maybe we could start with section 40, subsection 1, and we'll just go through if that's helpful. I think it might just be clearer.
Thank you.
So page 9, tab 3, under the heading Deprivation of Citizenship, subsection 1, in this section, a reference to a person's citizenship status is a reference to his status as a British citizen. We don't need to look at the others. By subsection 2, the Secretary of State may, by order, deprive a person of a citizenship status if the Secretary of State is satisfied that deprivation is conducive to the public good. Subsection 3, which is not material for present purposes, deals with deprivation of citizenship following registration or naturalisation in cases of fraud, false representation, concealment of material facts. Then subsection 4, which we just touched upon, the Secretary of State may not make an order under subsection 2 if he is satisfied that the order would make a person stateless. And then 4A, which was added by amendment, but that does not prevent the Secretary of State from making an order under subsection 2 to deprive a person of a citizenship status if A, the citizenship status results from naturalisation, B, the Secretary of State is satisfied that the deprivation is conducive to the public good because the person, while having that status, has conducted himself or herself in a manner which is seriously prejudicial to the vital interests of the United Kingdom, any of the islands or any British overseas territory, and C, the Secretary of State has reasonable grounds for believing the person is able, under the law of a country or territory outside the United Kingdom, to become a national of such a country or territory. Now, it's not at issue in the present appeal, but 4A wasn't originally in the statute, it was only 4.
When was it put in?
I'm sorry, I'm trying to remember the date. It's not in the footnote. I can tell you the circumstance. I think Mr. Squires.
It's Order of Chamberlain.
Yes, yeah. No, we don't have a date.
don't
So I can
know.
tell you the circumstances in which it was put in. So, Section 40, subsection 4 was intended to reflect the United Kingdom's obligations under the Conventions for the Prevention of Statelessness. There was then a case called Al-Jeddah in the Supreme Court, where it was argued that if a person could avail themselves of another citizenship, so they were entitled to another citizenship if they applied for it, for example, but they hadn't done so, they weren't caught by subsection 4, they weren't entitled to the protection of subsection 4. Briefly. The court held that that was not the correct interpretation, and that subsection 4 simply directed the Secretary of State to consider whether the deprivation would make the person stateless, not whether he might then obviate the effects of that by getting another citizenship. However, the Convention on Statelessness wasn't quite so generous as domestic legislation, and it did provide an exception in the terms of 4A for people who could acquire another citizenship. So following Al-Jeddah, subsection 4A was added to track the Convention rather more closely.
So all of these issues about statelessness under 4 and 4A would arise for consideration if a notice, not jumping ahead, if a notice is given and the person seeks to appeal.
Yes.
So all this argument about are they stateless, and if so, for example, does 4AC
My Lord's
apply?
absolutely right, and of course D4 does have an appeal pending in SIAC. We know following Shamima Begum that the approach to be taken is to look at matters as they stood at the Secretary of State's decision, and it's essentially a judicial review approach. So looking not just at status is not technically a judicial review approach, but looking at the public interest and national security, SIAC will then review the Secretary of State's decision that deprivation is in the public interest. So the merits of the case, broadly speaking, are all to be considered in the context of the SIAC appeal.
Yeah.
And it's for that reason that when we come to the facts, I'm going to be able to deal with them very briefly, because although D4 has a far more wide-ranging case on the merits, which she's advancing in her SIAC appeal, for the purpose of this judicial review, the claim turned on the strict procedural points about service of notice. And don't go beyond that. So the parties are agreed, and the judge at first instance took it on the basis of the very short agreed facts, and there's no reason why this court in our submission shouldn't do the same, and either party invite you to go beyond that.
Right, so we've looked at 4A.
So then the provision in section 40, which is relevant for the purpose of this appeal, and that's subsection 5, before making an order under this section in respect of a person, the Secretary of State must give the person written notice specifying that the Secretary of State has decided to make an order, and then it'll be the reasons for the order, and at C, the person's right of appeal under section 40A1 or under section 2B of the Special Immigration Appeals Commission Act 1997. And as the court will probably be aware, if the Secretary of State certifies, for example, that the reasons are reasons which have to be kept closed for national security reasons, such a certificate effectively effectively operates to transfer the appeal to SIAC. And this is such an appeal, so it's pending before SIAC at the moment. The right of appeal is the same. So what Section 40 envisages is a two-stage process, a decision to make an order, which is then followed by the order itself. But it's the decision which considers the merits and the substance, and it is the decision and not the order which gives rise to a right of appeal to SIAC, or indeed to the tribunal in a non-sensitive case.
Well, why do you say it's the decision that gives rise to the right of appeal, just on the wording of 5? I mean, why is it not a three-stage process?
I suppose in a way you could say it's a three-stage process, because a person has to be given notice of the decision in order to trigger the time for appealing.
So, I mean, I'm just concerned really about what the effect of this decision is. So we have the first thing that happens is the Secretary of State makes the decision,
Yes,
right? He's decided to make an order,
yes,
or she has decided to make an order. The second thing that happens is, before making the order, the Secretary of State must give the person written notice.
yes,
The second thing.
Yep.
And the third thing is the making of the order.
yes.
So if notice is not given, does the decision stand?
The decision does stand, and the judge so found. There's no cross appeal on that, and in my respectful submission he was plainly right. There's quite a lot of authority on the point. We haven't troubled you with it because it's not at issue here.
Right, okay.
But he did decide as well, didn't he, that he quashed the certificate, didn't he, and made a declaration that this individual's nationality remained British.
He didn't quash the certificate, he quashed the order.
Sorry, quashed the order.
Yeah. In fact, I think he decided in the end that he didn't need to quash the order, but he made a declaration that the
He
order
declared.
was void.
He declared.
There
And
was
said-
some discussion about
Yeah.
what. Yes, exactly.
So what did he precisely declare?
Should we turn to the order? It's at page 60
Go on.
of the core bundle. I'm so sorry, my memory failed me. It's at 58 and 59. It's the judgment that starts at 60.
The order which purported to deprive D4 of her British citizenship was made in breach of section 45, and so is void and of no effect. D4 was from that date and remains a British citizen, brackets, notwithstanding, I mean I'm adding, but notwithstanding the decision made by the Secretary of State to deprive her
Yes,
of her British
Yes.
citizenship.
yes, precisely.
Right, okay.
So when I say it's a two-stage process, what I mean is the decision is in two parts. There is a substantive decision that a deprivation order should be made, but then the making of the order is a separate step. And my Lord's, of course, quite right that the intervening step to be taken is the giving of notice. But those actions often take place very quickly, and as we'll see in due course, it used to be that the decision had a suspensive, that an appeal had a suspensive effect on the making of the order. So the process used to be decision, notice, time for appealing, and if an appeal was brought, it wasn't until that appeal was finally determined that an order could be made, but that was, the suspensive effect was removed by the 2004 Act. So the process now is that, as happened in this case, the steps can be taken quite rapidly. The Secretary of State can make the decision, give notice the same day, and make the order as soon as notice has been given.
And what does it mean to make an order under section 45?
Would it help to look at the actual documents in this case? So you've got them in the core bundle. Let's find my note.
So it's the order that deprives the citizen of the citizenship.
It is.
Order.
Yes.
That's what 2 says.
Yes.
By order. And before she can make an order, she has to make a decision and give notice.
Yes. So the decisions in this case are actually in the supplementary bundle.
Page 3.
Sorry, I've mislaid my notice, but I know where they are.
Page 3 is the notice,
Yeah.
and page 4 is the order.
Thank you. Yes.
I mean, an order, normally we associate with courts. So what is the nature of this instrument of force?
Well, it's an instrument issued pursuant to the statutory power in section 40. If you recall, if we go back to that, sorry to jump
Are there
around.
other areas where orders of this kind are made?
I beg your pardon, my lord?
Are there other areas in the immigration legislation or
Yes.
citizenship legislation where the Secretary of State makes orders?
Yes. Well, deportation orders will be another example.
They're made by the Secretary of State.
Yes.
Deportation orders. Yeah.
Yes. I appreciate it is terminology more commonly used for orders of the court, but it tracks the statutory language. If we go back to section 40, subsection 2, the Secretary of State may, by order, deprive a person of a citizenship status.
Yes.
I mean, it's slightly odd, isn't it, to have a decision, which is also a formal document, see page 3, followed by another formal document of the same date, is it? Are they dated? The second one is dated. Is the decision dated? No.
The decision isn't dated, but you have a witness statement at page 104 of the supplementary.
Page
bundle.
3 isn't the decision, is it? It's the notice of the decision.
Yes, but the notice of decision is effectively
That's it.
the decision.
There is no other written record of the decision.
No. What you have is the decision, a note for file that was given to the Secretary of State. In fact, the Chancellor in this case, because the Home Secretary was unavailable.
Where's the note to file?
If we pick it up, they're exhibited to the witness statement that you have in the supplementary bundle at pages 103 to 105.
Yeah.
At page 104, paragraph 7,
This is Miss Wentworth.
that's right, my lord. You have the sequence of events. So on the 27th of December, the Chancellor issued a notice pursuant to section 45 that he intended to make an order pursuant to section 42 to deprive D4 of her British citizenship on the grounds it was conducive to the public good. The notice stated it had been assessed that D4 had travelled to Syria aligned with ISIL, stated it was assessed that D4's return to the United Kingdom would present a risk to the national security of the UK, and 3, set out information about D4's right of appeal. The notice was served to file pursuant to section 10(4)(b)(2) of the 2003 regulation, paragraph, and it's exhibited. So the note to file is at page 107. In fact, if we try and take these in sequence, the decision, which you've already looked at page 3, is here again at page 109. So the notice records the decision.
Are you going to come back to look at this?
I'm happy
What
to.
was your... I mean, I don't... Because I've got some questions about this.
Right. Well, shall I?
No, I don't want to interrupt your flow.
No, I wasn't going to go through it in detail because there wasn't really an issue below. I think there was one here about the contents of the notice of decision. It was the question was whether it had been
It's
served.
the note
or
to
not.
file, we looked at the moment is 107. That's where you are.
I'm at 109.
I'm sorry.
Well, we've seen 109, but the
You
note
have seen
for
109.
file, presumably, does the note for file is dated the same date as the notice, as the notice is not dated at 109,
No.
but the date of the note for file is the same date as the order.
The order, yes. And they're out of sequence
which
here.
order
So the
are they?
sequence is
Sequences, yes.
109,
Mm.
notice of the decision.
Yeah.
107,
Note for file.
note for file.
Yeah.
And that simply records what
And
happened.
then the order.
And then the order, exactly,
111.
which is at 111.
Right. So, my lord's got a question. We've looked at the notice.
A note to file.
And
Right.
you have a question on
About,
note for file.
well, it's about, and I'm conscious we're jumping ahead here, but because we haven't got to the regulation.
No, not yet.
But at some point, I'd be interested to just tease out the passage where the third paragraph, where the reason is given for not serving at the last known address.
Yes. Well, shall I just make
I mean,
myself a
that's
note?
what- When we get to the regulation,
I'll marry the two up for. Yes.
thank you.
That'd be helpful. I'm happy to do it now. If you
No, because obviously, going through we're about to get to the regulation.
Yeah.
Or
Yes.
At some point we will.
Okay, we're going to get to them, I hope, quite soon. So that was the sequence of events, and as well as the witness statement, you will see that the order itself, at page 111, starts under the heading, "It is hereby ordered, in pursuance of the notice issued by the Secretary of State for Home Affairs on the 27th of December 2019, that," then D4, although her full name's given there, and place and date of birth, be deprived of her British citizenship on grounds of conduciveness to the public good. The Secretary of State is satisfied that D4 will not be rendered stateless by such action. So those are the underlying documents.
And that the order is not signed by the Secretary of State.
No, the order doesn't have to be signed by the Secretary of State.
Right?
So that's the sequence of events provided for in section 40, and those are the documents in the present case. Section 40A, which you have at page 11, deals with appeal rights, and I summarise the effect of that to you. If the Secretary of State certifies the decision was taken wholly or partly in reliance on information which in his opinion should not be made public for the specified reasons, subsection 2. Subsection 1 shall not apply. Subsection 1 gives the right of appeal to the first tier tribunal. But at tab 5, page 18, you'll see that a person who is prohibited from appealing to the first tier tribunal by that provision has a right to appeal to the Special Immigration Appeals Commission instead. That's section 2B of the SIAC Act. Again, it's not controversial that that's how the statute operates and that this is the provision under which D4 is appealing. So we've looked at 40 and 40A, and then section 41, which is the enabling provision, still at tab 3, and it's at pages 12 to 15. Yes, It's headed Regulations and Orders in Council. Subsection 1. Secretary of State may, by regulations, make provision generally for carrying into effect the purposes of this Act, and in particular provision, and you will see that there is a long list of things that the Secretary of State can make provision for, but at the penultimate paragraph of page 12, you have little e. So, in particular provision for the giving of any notice required or authorised to be given to any person under this Act. And that's the power under which the regulations at issue in this case were made.
Sorry, in the long list, which number is it? I'm sorry.
Sorry, it's E, my lord.
D.
E.
E. Yeah, but
Penultimate provision on page 12.
And when you say the regulations were made, they were made under 41(1)(e), weren't they? They've pinned their flag to that mast, not under the general power at the beginning. I can't find the...
No, well, they don't specify.
Your case
but
is.
In my respectful submission, the general power is in 41(1), and then little a all the way through to
Wherever it ends up.
wherever it ends,
Yeah.
are giving particular instances of the use of the power. So that power may, in particular, include regulations making provision for the following things.
Do you-
It's not
do you
exclusive,
rely-
but
But that, yes, I'm sorry, ma'am.
no, you can.
But maybe we're sort of getting quite close to the point here, aren't we? Because it may be
Yes.
said that what the effect of Regulation 10.4 is effectively to dispense with notice altogether, in other words, not to give notice. So then the question arises whether the power not to give notice is within Section 41(1) or not.
my lady's quite right. Not only may it be said, that's exactly what Mr. Justice Chamberlain did say,
Yeah.
accepting the submission of my learned friend Mr. Squires. And of course, we say that's where he fell into error.
Because just looking at it on the page, well, that's why I ask you, do you say, so really just to clarify, do you say that the regulations come in as a form of notice giving under little e, or do you say they sit under 41 subsection 1 without getting to the particulars, under the general power?
Could I think about that? I think that I would say they come under the general power as exercised in particular in those circumstances. That may not be very much of an answer.
Is that consistent with the wording of the regulation?
Well, I was just looking at the regulations, and I don't think that the version we've given you has the heading, although we'll look for that and provide it electronically as well as in hard copy as soon as we can.
I think it's very important as to what the regulations were purporting, how the regulations derived their vires on their face. I mean, all we're given here is, this is tab 6, is it?
It is tab 6.
And it says, I see, and all we're given is just 10.
Yes. Now that's why I'm hesitant about answering my Lady Justice Whipple's question, because 10 forms part of, you see from the heading in smaller font at the top, British Nationality General Regulations 2003, and I suspect that the introduction to those general regulations is going to say something like, pursuant to the power conferred by section 41(1), the Secretary of State. So it may not specify which regulations were made under, it may rely on the general power, but I don't want to just say that without checking. So if we get hold of a copy, we'll do that as quickly as we can.
And 10.4 itself is a 2018 amendment, isn't it? So we'd need to track that through as well and see what that
Yes.
says. We could, please.
What we have checked is that little e was originally in section 41. It's not one of the ones that have been added by amendment. And I can tell you that there were previously regulations governing notice, because there's been litigation about them, and that the amendment varied the content, but they didn't introduce regulations about notice for the first time. But we will come back and give you chapter and verse on that as soon as we can.
It was in 2018 that the contested provision was
Precisely,
introduced, wasn't it?
yes.
So whatever was happening,
Yeah.
and it's a point that you
Yeah.
both
From,
argued.
from recollection, it was last known address before that, but we'll
Yeah.
get the previous ones and check
Please.
all of that for you. I'm so sorry, we should have done
Yeah,
it sooner.
yeah,
I
it's
should have
fine.
anticipated it would be helpful. It plainly is.
Well, it says, in exercise of the powers conferred upon him by section 41(1) in brackets and 3 in brackets of the British Nationality Act,
That's extremely helpful.
1981, and then it's got a footnote, chapter 61, hereby makes the following regulations. So 41(3) we should look at.
And you have that at page 14.
41(1) and 41(3), which says regulations may make different provision for different circumstances.
It hadn't so far occurred to me, or indeed been suggested by the respondent, or indeed by the judge, that 3 was particularly material in this case.
Well, why not? I mean, it makes express what would otherwise be implicit from the words in particular.
Yes, I think it would otherwise be implicit. I suppose that's why nobody has particularly gone to it, that the regulations may make different provision for different circumstances.
I mean, what troubles me about this case is that I'm not quite sure, and it may not be absolutely relevant to the point of construction, but I think it is important what the government is supposed to do in a situation like this. So let's assume the judge is right for the purposes of argument that notice means giving and even receiving notice. Had the Secretary of State given notice to the last known address of the person in England, no doubt it would have been said, well, you knew the person wasn't at the last known address of, you knew that she was in Syria, so that's not effective notice.
Absolutely.
So what I'm struggling for is, what is the legislation intending the government to do, because it is directing its mind to the situation of the kind we're concerned with here, because we know this amendment was made in 2018, was it?
Yes.
Something like that. So
The
there is
amendment to the regulations, yes.
the amendment to the regulation was in 2018. So what's the intention? When the government knows the person is uncontactable in a foreign country, a foreign, let's assume for this purpose, contact is not possible. I mean, we say that, but of course people, even in refugee camps, have mobile phones.
May do, yes.
Or may do. So, and I thought there was some evidence here of contact having been made with this person or the person's relatives. I mean, I'm trying to work out what government is supposed to do
Well, that's a very good question, if I might respectfully say
under
so.
this legislation.
Yes. So the regulations, in my respectful submission, are expressly directed to that sort of a situation where there is no practicable method of giving notice in writing, delivering written notice, which is what is required, to the person in question.
Well, that's also, I mean, that's so analogue, this idea of notice. I mean, you may think I sound like a broken record, but we live in a digital age, and the only reference to anything digital is, I think, email in this thing. Whereas, actually, probably social media would be the best way of actually getting things across.
Yes. That sort of leads on to my next submission, which is that the enabling power dates back to 1981. So it's probably unlikely that it would have had this specific situation in mind.
It's very animal.
But Parliament must have had in mind that there would be a very diverse range of circumstances, potentially a very diverse range of circumstances, in which it was in the public interest for the Secretary of State to exercise her deprivation powers, and where it might not be practicable to give notice in writing in accordance with the general law.
Why didn't Parliament then include an express power for deemed service?
We're
If it's
leading
so
on to
obvious,
we're leading
as
on
you say it is, why
Yes.
isn't the power there?
No, well, but leading on to my next submission, to my submission once we've finished looking at the regulations, but my first submission is going to be when we get there, that there are three ways that Parliament can make provision for notice. It can either simply make a provision of primary legislation requiring notice to be given, and then one looks at the general...
Can we just take this slowly and start
Yes,
at
of
the
course.
top, if you don't mind, Mr. Renetti? I think this is quite an important submission. So there are three ways that Parliament can do what?
It can address how notice is to be given. So,
Yeah, one.
firstly, it can simply impose a requirement
By primary legislation.
by primary legislation to give or serve written notice and say no more. And in those circumstances, the general principles governing the giving of notice will apply. Then one looks to the authorities, and one will then argue about whether the notice needs to be received or it's enough for it to be delivered. But there are general principles in the case law.
Yeah, I wanted to ask you about this. The general principles in private law are about tenancy notices, all sorts of notices in every aspect of private legal relations. Do you say that those authorities are applicable to the public law context, or do you say they should be looked at carefully, or do you say they're inapplicable?
They should be looked at carefully, and we'll go to the cases in a few moments. But some of the case law does refer to provisions for the giving or service of notice, both where it's a contractual requirement and where it's a statutory requirement. And while the principles may not be identical, they are generally broadly similar. So I do say yes, that very careful consideration needs to be given, either to the precise contractual terms or to the terms of the statute.
So you say private law is not automatically inapplicable?
No, not necessarily. So that's option one, simply impose a requirement for the giving of notice and say no more.
Yeah.
Option two is to impose the requirement but regulate in the primary legislation itself
Sorry, impose a requirement
to give notice,
to give notice.
sorry my lord,
Yeah.
and include in the primary legislation itself specific provision as to how notice may be given. And we'll look at an example of a statute that did just that and how the court approached it in a moment. But that can include, for example, presumptions, it can include deeming provisions, and there is also, of course, the Interpretation Act, Section 7, which the court will be familiar with, which deals with the timing of receipt when there's service by post. third option is to impose a requirement to give notice and coupling that with an enabling provision by which provision for how service is to be given, notice is to be given, will be addressed in subordinate legislation. And there are plenty of examples of that as well.
Yeah.
And which do you say applies here?
I say the third one.
And what did the judge say?
Well,
The judge said the third one didn't work because what you were doing in the primary legislation was imposing a requirement to give notice and using the secondary legislation to dispense with giving notice.
yes, in a nutshell, that's right.
And that couldn't work, and that if you wanted to be able to dispense with giving notice, that had to be something for
Yes.
the legislature, so it had to be in the primary legislation, so that 3 wasn't open to you. You had to use 2.
Yes. Although he sort of qualified that because he did seem to think
Yes, you could have deeming.
you
yeah.
could have deeming
I
provisions.
want to hear your submissions on that, whether
Yeah.
you think that flies or not. Because
Yes.
on one view, you might say it's
Too generous.
once you've gone down there, there's no middle ground. You
difficult.
can't do it by
Yes.
you can't deem
Yeah.
notice to be given when in fact what you're deeming is disapplication
Yes.
of the notice requirement in the
Yes.
first place.
My answer to this, broadly, key answer is, if Parliament simply intended the general rules about the giving of notice to be applicable without qualification, all it needed to do was legislate under option 1. So simply impose a requirement for the giving of notice. And then all the general principles about what giving notice means would be applicable. The only purpose of the enabling provision is to enable the variation of those general principles.
So that's your key submission.
That is my key submission, yes. Now,
And,
Sorry,
and
one more from me after you.
well, I mean, I was just going to say this, that of course notice is not quite as binary as people like to think. It is inherent in Section 7 of the Interpretation Act that about postal service that you give notice, but in many cases the person who's given notice validly under the law does not receive it.
yes,
And so the concept of the judge's binary view, which was, well, with the one hand you give notice, but with the other hand you're legislating to take it away, it's the very antithesis of giving notice, is of course eloquent and attractive and neat, but may actually just be a function of what notice is often about.
well, we'd say that's precisely right with respect, my lord. Yes, absolutely.
Because notice doesn't always, is not always effective. But of course the contrary position is quite strong, as you obviously accept.
Yes.
Which is that you can say, well, what's it about if it's not about getting it to the attention of the person concerned?
Yes.
Because
absolutely.
they have to appeal
Yes.
within 28 days.
Yes. Although, of course, there is a provision for
Yes.
extending time, which is almost invariably, in my experience, exercised in these cases, and the Secretary of State doesn't oppose exactly what happened here. But I was going to say something else, and my lord triggered a number of thoughts there. I think the first thing is that I will, obviously, my lord's completely right, and I'm sure that both sides and all counsel have read more cases about notice in preparing this case, both at first instance and for appeal, than we knew existed. And it is indeed extremely complex when one's looking at the general principles.
Well, you never practiced in the Chancery Division,
No.
where there are cases about notice are
To a penny.
to a penny, and
Yes.
they certainly were in what I would call the old days, which
Yes.
is when I was a junior in the Chancery Division. I mean, we used to have them all the time.
And we'll see in due course when we look at the case of Allan that it continues to be something which troubles this court as well as courts at first instance. And there are so many variables as to what can and can't happen, whether the notice is intercepted by somebody else or it's simply ignored in a pile of junk mail. Does that make a difference?
Well, my lady
Can
had a
I
question.
just pick up that point, really, which is that you were interested in relying on the first of your three ways of doing it. So you just have a fairly bland primary legislation power that says you serve written notice, and then you rely on the authorities. I think the point that I stumbled on a bit, as did Mr. Justice Chamberlain, is when you get to this power being the antithesis of giving notice. All the other things you're talking about in the common law are variations on a theme. You could say to yourself, well, some effort's been made to give notice. It may not have got to the person, but efforts were made. This is a bit different because no effort's being made. It's just being put in a drawer. So service is being dispensed with. So my question to you is simply this. Are within the authorities, this vast soup of authorities, do we find any authorities that say, as a matter of common law, when we talk about notice, we can mean not giving notice?
Oh no, if it was simply
It doesn't go
common
that far.
law and the general requirements,
Right,
I would accept that no, that wouldn't be permissible.
right.
I'd probably go further if it's of some reassurance to the lady now, that if the Secretary of State made regulations which simply provided, without more, that notice may be given by service to file, putting it in a drawer, then that would be, well, certainly our case would be immeasurably weaker, because I accept the Secretary of State has got to enact a reasonable scheme in the regulations, and that, and in fact that's consistent with what I think it's the House of Lords rather than the Supreme Court still, said in Anno Frieva, you've got to take reasonable steps. What's key to the regulations, and I was in two minds about whether to continue with the regulations, because I know my Lord Justice Baker was interested in them, or try and move on to the cases, but I think maybe we'll deal with the regulations now. What's key about them is that they provide a reasonable scheme where service to file is not an option if there are other reasonable, realistic options that could practically be used to bring the notice, to give written notice to the person. It's the sort of the backstop, if I can put it that way, when one goes through the steps, and it's only if certain quite tight constraints are met that you can. So if it was simply a case of the Secretary of State enacting regulations saying, I think the judge said very, very colourfully, I'll put it in a desk drawer and lock it, then, I don't think we'd be here.
But just going back to your three options, it just strikes me that one doesn't really work because the authorities aren't going to help you in the particular circumstance we've got here, where you don't know there's no practicable way of giving notice. So you have to be in the territory of two or three, don't you? What we're arguing about is the government chose two, whether that works or whether really your only option is to go into three and say that primary legislation not only requires the giving of notice but also includes something saying there are circumstances in which you don't have to give notice.
My option two was that the primary legislation itself made provision to depart from the general principles. My option three was this option, which is that Parliament confers any...
Sorry, I've gotten the wrong way around there.
Yeah.
My mistake,
Yeah.
I'm so sorry.
So I don't think there's any question of us being within two, because the primary legislation simply confers a broad enablement.
I think my lady's question was that you might have to, what she was suggesting was that you had to be within two in order to succeed in doing what you wanted to achieve within two.
Yes. And yes. Save that. That's not what the judge held, because he seemed to consider that other deeming provisions in subordinate legislation were legitimate. What he seemed to consider was that there had to be some specific mention of deeming. And we say that's absolutely not a legal principle or a rule of law, that you've just got to look at the enabling provision in context and say, is this generous enough? Is this within the reasonable anticipation of Parliament?
The judge might be wrong about that. That other legislation works. I mean, he might be wrong on both counts. So you can't assume that is the be-all and end-all. But your main submission, as I understand it, which you'll develop, is that this is a reasonable regime for Parliament to have entered into, to have provided for in both the statute and the regulation, and for the court to drive a coach and horses through it on this rather binary basis that notice always has to be effectively given with the intention of receipt is too narrow.
Yes. Yes.
And you were going to develop that by looking at the regulations.
I was. Shall I move on and do that now?
Why don't we do that?
So that's
We're looking at 10.
yes.
Is there anything else in the regulations that we should be looking at?
I don't think so. No.
Well, I'm going to satisfy myself about that by looking at them.
Well, I'd be very grateful if my lord did. We'll also look at them again. And if there's anything that you'd like us to provide, we'll do that.
Well, just looking briefly, 2 is an interpretation provision. 3 is about applications. 4 is about authority to whom the application is to be made, the authority. 5 is about persons not of full age or capacity. 5A is knowledge of language and life, citizens' oaths and pledges, arrangements, conduct of citizenship ceremonies, certificates of naturalization, biometric information, applicants under 16. Doesn't look as if anything much.
Part 3 is where the we find 10 declarations of renunciation.
Declarations of renunciation is section 8.
Because, of course, the 1981 Act is very wide-ranging and it deals with acquisition of citizenship as well as matters such as renunciation and deprivation.
And then, 11 might be more relevant. Cancellation of registration of a person deprived of citizenship, part of the same regime.
Consequences that their name shall be removed from the relevant register.
And evidence under 13. A document may be certified to be a true copy of a document. Yeah. Revocation. Okay, well, there doesn't seem to be. You're probably right that 10 is what we need to look at.
Quite a relief.
I'm sorry to be so.
No, it's a really important case. It's a really important point. And if both sides have missed something, well, we're really grateful the court brings it to our attention.
Right, 10.
So, Regulation 10. You'll see that by 10.1, where it's proposed to make an order under Section 40 of the Act depriving a person of citizenship status, the notice required by Section 45 of the Act to be given to the person may be, and then a list going down to G1 and G2 of ways in which notice may be given, which includes personal service, giving it to the person by hand, sending by fax, email, courier, document exchange, post, recorded delivery or not.
And this was enacted in 2003.
The original regulations were
This
enacted.
one.
I think 10.1 was unchanged in 2018, but we'll bring the 2003 regulations, the previous regulations.
You've got fax and email. Email was quite young in 2003, but certainly well known by then.
Courier. 4 is, was the amendment in 2018 the addition of 4?
Yes, but I think there may have been some variation of other.
Was 1 to 3 changed at all?
That's what I think there may have been some changes to 1 to 3 as well. But
We could check.
key addition.
Look, I could check on my phone, but Lord could check on his computer. Was because 3? I'm going to ask you about 3 amongst other things. So is that as per the original version?
No.
Okay.
Sorry, that was not What did you say? That wasn't
No,
checked?
I think our original bundle had the previous regulations,
Right.
previous authorities bundle, and they got pruned out. I think we were all concerned not to deluge you with too many authorities. We made it a bit over enthusiastic in our pruning. So version 1 of the regulations was enforced from the 1st of April 2003 to the 8th of August 2018.
Have there been two versions?
Yes.
Just two?
It
Well,
looks like
Regulation
this.
3 of the British Nationality General Amendment Regulation of 2018 said, by para 3, for Regulation 10 of the 2003 regulations, substitute this. So you probably need to go, if you want to see, which unfortunately the legislation.gov website doesn't give you the previous version.
No.
I've got the original version of the regulations 2003.
And I've got that on Westlaw.
Does that give you the original version?
Yes. So the original version didn't have the list in subsection 1.
Right. So this actually was introduced in 2018, the list.
I want to double check it didn't come in at any intervening stage, but it certainly wasn't in the original. The original provided for, in a case where the person's whereabouts are known, by causing the notice to be delivered to him personally or by sending it to him by post, and B, in a case where that person's whereabouts are not known, by sending it by post in a letter addressed to him at his last known address. So those were the two options. And 3, in the original version, addressed timing.
Deeming to be given.
Yes. Shall, unless the contrary is proved, be deemed to have been given when the notice is sent by post from and to a place within the United Kingdom on the second day after it was sent.
And then 28 days.
28 days for outside the United Kingdom, and in any other case on the day on which the notice was delivered. Could I just turn my back for a moment? Mr. Deacon's just going to check to see if there was an intervening version, but that was the original, and here we have the current one since 2018.
Yeah. Okay, well that's one. That's taken enough time. Let's look at 2.
So, it relates to where the notice is sent by fax. It must be sent to a number provided by the person or the person's representative. Sorry, we didn't look at G, which is probably important, because it can also be sent by any of the means set out at B to F. So not delivery by hand, but by fax, down to and including by post.
And to a parent.
To the person's representative, or if the person's under 18, their parent or guardian.
Right. So it's important. This person, D4, is not under 18. No. But if she were under 18, there wouldn't have been a problem because it could have been sent to her parents if in the United Kingdom.
Yes. Yes.
Right. I mean, that's something that was in my mind.
And in terms of the person's representative, you'll see that by regulation 10.5, which is over leaf, sorry, 10.6 is over leaf, in this regulation, representative is a person who appears to the Secretary of State to be representing the person to whom the notice under section 45 of the Act is required to be given, and where the notice is sent to the person's representative by any of the means set out in paragraph 1, it is deemed to have been served on the person in accordance with that section. So we have another deeming provision there.
Mm-hmm.
So that's 1, 2 and 3, and then the key provision for our purposes is 4. So 4 can only be relied upon in strictly confined circumstances. Where A, the person's whereabouts are not known.
Well, what happens then if you do know the person's whereabouts? I mean, I thought they did know the person's whereabouts. This person was in a refugee camp in Syria.
Yes. There's a decision of Mr. Justice Irwin, as he then was in SIAC, remember the case, H2, which says that whereabouts, for the purposes of the regulations, means knowing the whereabouts with sufficient specificity to be able to effect service by notice in writing. So
What's
it
it
doesn't
called?
just, one can't say, well, the Secretary of State, I mean,
H2.
Did you get the reference for that at some point?
Yes.
Or Junior just at some point?
Yeah.
Thank you.
I was in it, so I remember it quite clearly. And the argument there was where the Secretary of State knew that a person was in a particular part of a particular city, or it was suggested the Secretary of State knew that, and about whether more inquiries could have been made to find out exactly where he was and effect notice.
So B, so that whereabouts unknown, then B.
Yeah, and either no address has been provided for correspondence and the Secretary of State does not know of any address which the person has used in the past, or the address provided to the Secretary of State is defective, false, or no longer in use by the person. And we're in the third category here, no longer in use by the person. And
But was an address provided to the Secretary of State?
I don't think address was provided, but I think the Secretary of State did know of an address which the person had used in the past. Remember, there are 2 limbs to Little Roman 1.
Well, no. I mean, you said we were in. I'm sorry.
Oh, I see.
I thought you said we were in 4B2.
My lord is absolutely right. I think we're not in 2 at all.
No,
We're in 1,
B1.
which is squarely in 1. I'm so sorry, you're absolutely right.
Well, but I mean, we're not.
no,
are we?
Because
the
it
Secretary-
wasn't. I thought the notice to file said that
Yeah.
her last
No.
known address is no longer in use.
This is the
Yes.
point that we've got to the point I was going to ask you about. So it's this case purports to be in 2, doesn't it? 4B2.
But it's not.
Well, is it?
Well, now, I'm afraid the point hadn't occurred to me before, or to anybody, I don't think. I think the answer must be that the address provided to the Secretary of State must be wide enough to include any address that the Secretary of State knows which the person has used in the past. And I don't know whether an address had been provided or not at any point in the past.
Just talks about her last known address.
Yeah.
I mean,
It doesn't
is
say
there a conflict between 3 and 4? Working out how they fit in practice is quite, I'm having difficulty with. I mean, this is someone who had a last known address in this country.
Yes.
This is an adult.
Yes.
You see, I'm worried about this because I don't think, with great respect to that last submission you made, that the words address provided to the Secretary of State can include an address used in the past, because the alternatives under B are either no address has been provided for correspondence, or the address provided is defective, false, or no longer in use. And therefore, B is all about provision of an address. The emphasis is on provided in both sub-paragraphs. So the alternative is either no address has been provided or an address has been provided.
Yes.
And therefore you can't say it's not about the address being provided.
No. And I think, I'm sorry, it's my having scribbled on my version. The key word actually is the or between one and two.
Yes. So there has to be one or the other.
Yeah.
And the Secretary of State, in order to apply for, has to say, one, the person's whereabouts are not known,
Yes.
as construed in H2, which is fine.
Yep.
Secondly, either that he has or he hasn't, or she has or she hasn't been provided with an address for correspondence, so which of those applies, and that no representative appears to be acting for the person, or the address provided in respect of the representative is false or no longer used. Those are the three requirements. Now, are they satisfied here? Let's look at the notice, shall we?
Notice or the note? Notice.
Well, we've got to look at all three, perhaps, but the notice doesn't say anything about it, nor does the order.
Paragraph 3 of the note.
And the note says, sorry, which page is the note?
107.
107.
Thank you. Sorry. HOLA, which is the Home
Home Office Legal Advisors.
advised that service to file was appropriate given that we do not know her current precise whereabouts, so as to somehow affect service privileges. We assess that her last known address is no longer in use. This is permitted under the regulations. Well, that's inaccurate. I mean, not inaccurate in the sense that they don't know, but it's inaccurate in the sense that it doesn't deal with each of the three conditions. So is there evidence about the three conditions?
Well, there isn't, because this isn't the point that was being taken against us in the judicial review. So if it had been, I'm sure there would have been evidence addressed to this specifically.
So no point was taken on the compliance with 10.4's conditions.
No. The point being taken was that 10.4 was ultra vires.
Okay. Right,
And indeed, if you look at the judgment, the core bundle, page 62, paragraph 10,
yes.
the judge said this. In her original appeal to SIAC, D4 also argued that even if Regulation 10.4 were valid, the Secretary of State could not rely upon it because she did know D4's whereabouts and because her family still live at her previous address. But D4 has decided not to advance these contentions in this claim. I, therefore, need say nothing more about them. And indeed, for that reason, it's not a point that we looked at, certainly not in any detail.
No, I mean, I understand that, and that's fine, but it's less fine vis-a-vis what the legislation is intending to achieve. So it's very important, I think, for us to understand, in order to evaluate your submission, that the legislation is a fair process.
Yes.
To understand what this 10.4 does. So if we go back to 10.4 for that purpose, we see that the three conditions are not known in the H2 sense.
Yes.
Either an address has been provided or not provided, but in either case, I mean, the first one is strange, and the Secretary of State does not know of any address which the person has used in the past. I mean, that would be very unlikely, actually. because if the person has a British passport, the Secretary of State will automatically know of an address used by that person. So one is I'm sorry to bang on about this, but one is hardly ever going to be the case. And so this all turns on an address having been provided, which is no longer in use. So I suppose the answer to that is that will be every case, because when they got a passport, they would have provided an address.
I was just thinking exactly that. Yes, I think that must be the case.
So it's not as unlikely as it seems. So it's a regime for where person's not known about, gave an address for a passport which is known to be no longer in use because the person's abroad, and there's no representative, or the address provided is false, then you engage 4.
Yes, that's right.
So 4 is quite widely engaged, actually.
Yeah.
It must be quite widely engaged, because a lot of cases would.
Well, it's quite widely engaged in the circumstances as they have turned out to be in post-2000. Yeah.
So you were right in the
10 years
first
or so.
place. You were right when you said to my lady that 2 applied, but for the wrong reasons.
Maybe I get a half mark for that.
Yes.
But although it will in fact apply quite widely to cases like the present, it won't apply to the broad generality of cases where somebody is deprived of their citizenship because they have behaved appallingly in the United Kingdom, for example. So there may be all sorts of circumstances where the Secretary of State, the power to deprive is quite a wide one, as you'll have seen. And there have been cases, a number of cases, actually. I think Pham in the Supreme Court was one of them, where the person has actually ended up in prison abroad. I think in Pham's case, it was in the United States. So circumstances like that where the Secretary of State will have an address. So it's not that it's a broad general provision. But I suppose the key point is that the Secretary of State can't use this provision if the person's whereabouts are known with sufficient specificity.
It all turns on H2, doesn't it? Actually, because B applies to every case of this kind.
Of this kind.
And the question is whether the person's whereabouts are known. So the width of 4 depends on what that means. And you say, first instance decision, no appeal, ever, and that's been accepted for a long time, has it?
Yes, I mean, there was an appeal, but not on that point. There was an appeal on the case did go to the Court of Appeal. It was Baroness Kennedy acting for H2, but it wasn't on, I'm pretty confident it wasn't on this point.
I mean,
it
what
was on his
troubles me is
citizenship.
that the broader 4 is,
I'm so sorry, my lord, I missed that.
the broader 4 is, the less compelling your submission.
Well, in a sense, but I'd say that the fact that it arises in a significant number of cases of this kind doesn't mean it can just be used as a sort of default mechanism.
But isn't that what's happened?
Well, it hasn't, because the D4. Well,
How many people?
there is no issue but that D4 comes within.
Your Sir James's skeleton. There are 60 odd cases of this sort. Have I got that right?
Well, that's because numerically there has been a significant problem with people travelling to Syria to join Islamic State. But it doesn't mean that a person who can be contacted by post, for example, who can be tracked down to have something delivered to them by hand, for example, because the Secretary of State knows of a place of work, can simply have the notice served to file. It's
Has
only where
this been
10.4 is
used-
satisfied. Sorry.
In how many cases, I mean, maybe it's not information you want to give us, but in how many cases has 10.4 been used at all outside the Syrian situation?
Well, you get some indication of that in our skeleton argument. In the core bundle, page 42,
Which paragraph?
paragraph 5, my lord. If you pick it up 5 lines down, the Secretary, towards the end of the line, the Secretary has so far identified 63 cases where a deprivation of citizenship order has been made following service to file of the notice of decision. In 28 of those cases, the decision has been based on assessment that deprivation of citizenship is conducive to the public good. The remainder were deprived due to having acquired citizenship fraudulently. In a high proportion of those 28 cases, the individual concerned has also, like D4, been assessed to pose a threat to national security. So a high proportion of 28 cases. But the first example, so the person who's acquired citizenship fraudulently, is another good example of where subsection 4 might be necessary. So a person who's acquired British citizenship fraudulently, but could well be using a false name, the Secretary of State can't identify where they are, but they are somewhere using a British passport to which they are not entitled.
But with the case of D4, who had a last known address in this country, the Secretary of State could have given notice under 3B without resorting to these deeming provisions in 4. So that must be the case with quite a lot of the 63 who are adults.
Yes.
And in respect of children, they could be brought in within 1G.
Sorry, you said 13B. You meant 1.
What did I say?
You said 13B, but that's not correct.
You meant 10.3b.
10.
I meant 10.
3B.
I meant 10. I'm
But,
sorry.
but there's no indication here that she had a representative. Oh, I see. The person's last.
Yeah, the person you can send it to the last known address.
Yes.
And with a child
yeah.
under 18, you can send it to their
Yes.
parent.
Yes.
So, and D4 comes into the first of those categories. So, is the deeming provision being used as a substitute for the service provisions provided for under 10.1 to 3?
Well, my lord, it would always be open to an individual to say that the Secretary of State had abused the service provisions and had given service by a method which he should not have used, or a method that was unfair. It's a mistake in my respectful submission to just construe this as if by reference to one specific set of facts, because in this case it's right to say that the Secretary of State had a last known address and that, as I understand it, the people living there were family members. But there will be cases where the person has, for example, abandoned a tenancy, and it's not much use serving the notice on an address where maybe 3 other families have lived in the meantime.
But the regulation says you can,
The regulation says you can, yes.
because that's giving notice.
Well, that's right. I mean, apart from anything else, notices like this, or a deprivation of citizenship, we've got an anonymity order, is quite a sensitive piece of personal information. And we're much more sort of concerned these days with sensitive data and data protection, maybe than one was in the past. Simply serving it on a last known address when it's known that the person is no longer there may have been considered legitimately to be undesirable.
Well, I mean, okay, but it's a strange thing because in almost every case, one would have thought this concerns people who are likely to be abroad. In most cases.
Certainly in many cases, and that's
In
probably
many
enough, my
cases.
lords, yes.
And in that case, everybody who is abroad and British will have a passport. And they will have notified an address. And therefore, the last known address is known in every case. So 10.4 is not necessary in any case. And would the same arguments, let's assume that in this case, and I asked you this right at the beginning, that the notice had been served on the family home as the last known address. Would then D4 have said, you didn't give me adequate notice, this is ultra vires or improper? Or would they have said, no, that's what you should have? Or do they say now, no, that's what you should have done?
Well, I'm sure they do say now that's what you should have done.
Well, he sort
But
of
if they
says
had-
that, Mr. Squires sort of says that in his skeleton argument, but I looked at it quite carefully. I'm not sure he quite goes there.
No.
He mentions it and moves on, but I will look carefully.
Now, I don't understand the respondent to concede that that would be effective giving of notice.
No, I thought he didn't
No,
concede that.
I think they're very carefully not conceded that, because there always is the difficulty about whether it's good notice when you serve it on an address that you know the person is no longer at, and you have no...
I mean, if it were a person under 18, it would be fine,
Yes.
because then it
Yes.
would be a parent,
Yeah.
if it were the parent.
Yeah.
But for a person over 18, of course, you know, we're very concerned to make sure that privacy is adhered to. And as you say, serving it on the parents is of no value, although actually it might bring it to their attention, because
Might.
if they're in touch and they open the post and they've got mobile phones, they might well tell them.
Yes.
So it's a very difficult position for the Secretary of State, which is why I asked you right at the beginning, what is the Secretary of State supposed to do under these regulations? We're now seeing that she could have taken the easy way out.
Well, I think there would still be arguments about when notice had been given. And it's important to bear in mind, we looked at this originally, but that the respondent's case hinges on the sequence in which things are done. So the Secretary of State needs to know that notice has been given before making the order. One of the difficulties with simply serving it on a last known address is that there will be arguments, very well be arguments, about when it was received by the person. Indeed, if it was received by them at all, if it was delivered to them at all.
Except there's a deeming provision under 5 that it's next day.
Yeah, well, I suspect the next step would be to say that that was ultra vires.
Well, that was in the previous regulation.
Yeah, it
So
was.
it's in line with provisions throughout the law.
Yes, but it's just a presumption. A notice required to be given by Section 40, subsection 5 of the Act is unless the contrary is proved, deemed to have been given. So one will still have arguments, a witness statement by the family saying we didn't have any way of contacting her. So, here is the proof to the contrary. It's not been transmitted to her. She has not been given notice. It really is.
So it's a way of avoiding all these tricky arguments, these inconvenient arguments for the Secretary of State. She can avoid them by resorting to 4.
And there is case law in other jurisdictions to say that leaving notices with family members just doesn't cut it. It's not enough. It's
Yes.
a safe way of...
No. And
So it is a difficult...
No, and the Secretary of State has got to be in a position to know whether she can lawfully make an order or not in these cases, and when she can lawfully make an order. And in a situation which is not D4 situation, but it is a situation that arises, where it is thought that somebody might want to use their passport to travel, time may be of the essence here. The Secretary of State needs to know when she can act. And that's the problem with presumptions, and that's the problem with just taking the general...
Well, there are other steps the Secretary of State can take, aren't there, in respect of an individual who's using their passport.
She can...
She's not powerless.
No, well, she can make a temporary exclusion in order to stop them coming back to the United Kingdom. I don't know what she can do to stop them travelling from one country to another for the purposes of terrorism-related activity, for example.
I think Mr. Squires' speculation looks as though he's going to be able
I'm
to
sure
help remind you about that.
Well, she can cancel the passport,
Yeah,
but...
exactly, she can cancel the passport.
Well, yes. That may be of limited value if the person still has a passport and is crossing a land border with it. It's not really as
Well-
simple as that. There are measures available, but
Well, cancelling a passport means that someone going through crossing most borders wouldn't be able to get across on that passport, doesn't it?
well, there's no evidence about that. And I think when we're talking about the sorts of border crosses which are prevalent in
Yeah, it
other
depends
parts
which
of the
sort of
world.
border you're talking
course.
about.
Yes, yes, absolutely.
Okay. Look, I think we've probably been a little bit interventionist with you.
Well, I'm very grateful. It's
No, but
certainly prompted further thought on my part.
I'm also concerned that we finish this appeal in the course of today.
Absolutely.
And Mr. Squire's has got to have a good opportunity. So you want to go to the authorities, so I suggest you do. It's entirely my fault, not my colleague's fault.
Oh no, it's mine too.
It's entirely my fault probably for not having anticipated all of this to make sure it was covered in our skeleton argument. So we say that the plain words of section 41 confer a broad regulation-making power. But this is the third category of case where Parliament...
For the purpose of the statute. What's the phrase? 41. The regulatory power.
Yes.
I'm sorry to pick you up. A broad.
Not at all.
It's. I'm sorry, I'm interrupting. Right across the board, but it is 41. Where is 41?
It's at the end of tab 3,
Thank you.
towards the end of tab 3.
If you're relying on the broad power in 1, as opposed to little e, it's generally for carrying into effect the purposes of this Act.
Yes. And in particular, provisions for the giving of any notice required or authorised to be given to any person under this Act.
So giving of the notice is one of the purposes of the Act.
Yes.
Yes?
But it's
one of the particular-
a provision for carrying into effect the purposes of the Act.
Giving notice is a provision for carrying in the purpose of the Act.
I personally would doubt whether giving notice is a purpose of an Act. The purpose of the Act is about citizenship, and in this particular case, being able to remove citizenship in an appropriate manner.
Yeah.
I doubt whether the detail could be regarded as a purpose. I mean,
No.
my lord may be right,
But I would say that it falls within the carrying into effect the purposes of the Act, because in order to carry into effect the purpose of the deprivation power, you've got to give notice,
yes.
whatever that
Right.
may mean.
Okay.
So, as we've referred to, or alluded to in passing, the judge placed some weight on section 13 of the Counter-Terrorism and Security Act 2015, and I think it might be helpful to pick up his judgment on that point now. It's core bundle page 71, paragraph 45 of the judgment. That's probably helpful to read 44 and 45. So reason proceeded in 10 stages. At 44.4, Parliament can and sometimes does specify particular methods of giving or serving notice, which if used will result in an irrebuttable presumption that notice has been given and received. And he refers there to the case that we'll go to in a moment. This was done in the 1914 Act, but not in the 1981 Act. And I pause there to say that the 1914 Act deemed notice to have been given if it was served on the last known address. So it wasn't a presumption, it was a deeming provision. It cannot be said that the omission was a drafting error in the sense in which that term is used in INCO Europe. Well, it's not our submission that it was a drafting error. It doesn't satisfy any of the conditions set out by Lord Nichols in that case. We're not suggesting that Parliament has specified particular methods of giving service or that they were omitted because of a drafting error. 45 deals with my third category, which we say this falls squarely within. Fifth, Parliament can and sometimes does confer power to make regulations creating an irrebuttable presumption that notice has been given and received. Section 13(2) of the 2015 Act is an example of such a power. That confers power to deem notice to have been given, i.e. to create a statutory fiction that notice has been given and received when it has not. Parliament conferred no equivalent power in the 1981 Act, whether at the time of its inaction or by subsequent amendment. And that was very key to the judge's reasoning. The term statutory fiction was one taken from one of the authorities before the judge that we haven't put before you, but it just explains that the deeming provision is a statutory fiction which requires something to be treated as having happened or having been done when it hasn't been. And there's no issue as to that.
I'd quite like, can you send me just a note of that authority? I'd quite like to see that
Yeah.
authority, please, because I think there's an issue about how far you can stretch the word deeming, but it may be once I've read the authority that I change my mind on that.
Okay. So there are 3 points that we would make about this reasoning. Firstly, the Counter-Terrorism and Security Act is a 2015 statute, and we say that that's not a reliable guide to what Parliament would have intended some 30 years earlier when enacting the 1981 Act. Secondly, if we turn to the Counter-Terrorism and Security Act, which you have at tab 7 of your authorities bundle, the provisions in question deal with exactly what my Lord Justice Baker raised with me a moment ago, another sort of tool that's available to the Secretary of State, and that's temporary exclusion orders. So could we pick it up maybe at page 21 of the bundle? And you'll see by section 2.1 that a temporary exclusion order is defined. It's an order which requires an individual not to return to the United Kingdom unless it's returned in accordance with a permit or it's the result of the individual's deportation. Then overleaf at 22, under 4 supplementary provision, the Secretary of State must give notice of the imposition of a TEO to the individual on whom it is imposed. And that notice has got to include an explanation of the procedure for making an application for a permit by subsection 2. And then at 3, a temporary exclusion order, you see little a, comes into force when notice of its imposition is given. So just like the 1981 Act, we have a very clear requirement to give notice in the Act. And that is a requirement which gives rise to other procedural and substantive effects. So it only comes into effect when notice is given. The regulation making power is in section 13 at the same tab, page 26 of the bundle. The Secretary of State may, by regulations, make provision about the giving of notice under section 4 and under section 9. And then at subsection 2, the regulations may, in particular, make provision about cases in which notice is to be deemed to have been given. Now, in our submission, not only is a 2015 Act not a very reliable guide to Parliament's intention in 1981, but the words in particular are wholly consistent with a clarificatory provision which simply confirms that a matter falls within the broad enabling power in section 13, subsection 1. The fact that Parliament provided that the regulations may in particular provide for deeming doesn't mean that they can't also provide for a number of other matters. They don't need to be specified. It's not an additional power, not additional to section 13.1. It's explaining the scope of 13.1. The point might be a stronger one if the 1981 Act did contain provisions that said the regulations may in particular make provision about 1, 2, 3, 4 and 5, and deeming wasn't included. There'd be presumably arguments under the Euston Generis principle, but one had to construe the power in accordance with the specified uses to which it could be put. But we don't have that here. The in particular is, in particular, the regulations may make provision about the giving of notice. And you've seen section 41, it's a lengthy section with lots of bits to it. Because the 81 Act covers a very wide range of applications, methods of acquiring citizenship, methods of losing citizenship. It's a broad general enabling provision, cannot legitimately be narrowed because another statute decades later contains a clarificatory provision saying that in particular a power may cover certain matters.
Is it common ground on regulation 13.2 that the words notice is to be deemed extend to notice not being given in my language, so in other words a disapplication of them, so putting it in your top drawer would be covered by the words deemed notice?
I see Mr. Squires is nodding.
That's very helpful, thank you.
Sorry, I didn't get your answer.
Oh, it was the question was directed at Mr. Squires, I think, and he confirmed that yes, it's accepted that service to file would be covered by section 13.
As a form of deemed notice, even though the mental gymnastics that requires is quite extensive, because the thing you're doing is not giving notice.
Yes, yeah. And I think we come back to, the judge's term statutory fiction. It is a statutory fiction.
No,
we accept that if you look at it under the general law, it's not giving notice at all.
Yeah, but that's not unusual.
It's not unusual.
I'm saying,
No.
notice is often not given and then deemed to be given.
Yes.
So,
But it's not even trying to give notice. I think that's the point. That's the point the judge made. There's not the remotest effort to post anything or do anything. But anyway, I've got your answer. Thank you very much.
We say, and actually I think we've jumped back to a point that I've actually made already now, that there are constraints on the exercise of the power under section 41, that these should be identified by reference to ordinary principles of statutory construction. That is, that the power should be exercised consistently with a statutory purpose, and that the scheme of the regulations should, in the round, be a reasonable one.
well, I mean, that first thing is important, isn't it?
Statutory purpose.
Yes,
It is,
because
my lord.
if my lord was right, that the statutory purpose was giving notice, that would be different from the statutory purpose being to be able effectively and fairly to deprive people of citizenship.
Yes.
And your submission, I imagine, is the statutory purpose is effectively and fairly to deprive people of citizenship, and in that context, this notice these regulations relating to notice are reasonable and fair, taken in the round.
That is precisely my submission, and given the time, I won't try and reformulate it. I probably couldn't do so nearly as well. So could I turn then to the authorities? And I'm not going to take very much time with these. The key authority, we say, is the UKI Kingsway case. And you have that at tab 18 of your bundle, page 182. And this is a pretty up-to-date decision of the Supreme Court, 2019. And we thought on reflection that if you had this, it would eliminate the need for a plethora of other cases dealing with notice. So I wonder if we could pick it up at page 185. There's a single judgment, the judgment of Lord Carnworth, and you'll see that the other members of the court agreed with him. And the appeal raised, as he says at paragraph 1, a short issue as to the requirements for valid service of a completion notice so as to bring a newly completed building within liability for non-domestic freights.
Yeah.
Just for a short point, could we turn to page 188? Paragraph next to letter B is authority for the proposition that I alluded to earlier. No distinction drawn in the cases between serving and giving a notice.
Sorry, wait, which paragraph?
It's the second paragraph, begins with the words, it's parentheses, no distinction is drawn in the cases. Sorry, the number of the paragraph, paragraph 15.
Yes.
I'm so sorry.
I'm there, thank you. I misheard you.
And it's the final sub-paragraph within that paragraph. No distinction is drawn in the case between serving and giving a notice. Then Lord Carnworth refers to the authorities to that effect. And he says, Lord Justice Peter Gibson said in a case relating to the service of a notice under the Housing Act 1988, service is an ordinary English word connoting the delivery of a document to a particular person.
Well, there's no concept of service in this statute.
No. But authorities that deal with serving notice are equally applicable when the statute requires you to give notice.
So are you saying that we can replace serve with give in that
They're
last sentence?
interchangeable, I think.
So giving involves delivery of a document
Yes,
to a particular person.
yes. That's the general approach. I won't read them all out, particularly given the time, but you'll see that the statutory framework is set out at paragraphs 2, 3, 4. And at 5, you see that, as in so many provisions, service of the completion notice or giving of the completion notice is the trigger for an appeal. You see at paragraph 6, paragraph 8, which deals with service, provides, and again I won't read it all out, but it provides the service to be given by one of 3 specified methods. And then Lord Carnworth refers at paragraph 7 to the general provision for the service of statutory notice in the Local Government Act 1972. can we pick it up with the reasoning under the heading Service to Authorities, just above paragraph 15? For those who are working from hard copies, it's on the facing page. It's common ground that by virtue of the opening words of paragraph 8 of Schedule 4A to the Act, the three specific methods there set out do not do not exclude other methods of service available under the general law. There's no serious dispute as to what that entails. He refers to Sun Alliance. Sun Alliance speaks in terms of causing a notice to be received, but as we've just seen, Lord Justice Peter Gibson spoke of it in terms of delivery. But those are the methods of service available under the general law, as Lord Calmer said at the beginning of paragraph 15. And then paragraph 16 in our submission is key. Specific statutory provisions, such as paragraph 8, are designed not to exclude other methods, but rather to protect the server from the risk of non-delivery. As was said by Lord Justice Slade and Galinsky and McHugh in relation to a similar service provision in the Landlord and Tenant Act 1927, this is a subsection appearing in an act which contains a number of provisions requiring the giving of notice by one person to another, and correspondingly entitling that other person to receive it. In our judgment, the object of its inclusion is not to protect the person upon whom the right to receive the notice is conferred by other statutory provisions. On the contrary, section 23(1) is intended to assist the person who is obliged to serve the notice by offering him choices of mode of service which will be deemed to be valid service, even if, in the event, the intended recipient does not in fact receive it, which I think is exactly what my Lord the Master of the Rolls was saying. That is the purpose of making additional provision for service.
Well, I mean, one has to bear in mind that notices, that people don't often want to receive notices.
No.
They're generally things that people would not find welcome. And that's in this case, and also in the service of notices under the Housing Act or under any other act.
Yes. And
So-
going back to the purposes of the statute, if it was too easy for a person to evade deprivation of citizenship by effectively putting themselves outside the reach of the Secretary of State, that would plainly be contrary, we would say, to the statutory purpose, which requires, intends, that the power to deprive should be an effective one. I'm so sorry.
Being back in court is something not used to.
That is, we say, the key authority which outlines the principle, which is you have service under the general law, and then there can be additional provision to protect the server, specifying other methods of service, deemed service, which would not satisfy the general law. And as we have seen, as well as being included in primary legislation, that is frequently done by way of...
Is there any authority on it being a provision or principle that such powers, if necessary to protect the server, can only be used if, as it were, if all else fails, or if it's not possible to serve? Or does the server, under these provisions, have the power to pick and choose which provisions to use? In other words, to use the deeming provision if they want to.
I don't think there is, but if there was, I think that'd be something that learned from Mr. Squires would be more likely to be relying upon. I mean, I've accepted that it would be open to somebody to challenge what the Secretary of State did and say it wasn't consistent with the principles or reasonableness or public law principles. But as you've seen from the judgment, it's not an issue that was being raised in this judicial review, and so I'm reluctant to address it because we simply don't have the evidence.
How many
to
people
do
get
so.
deprived of their citizenship? I'm interested to know how many. What do these 68 represent? Is it a small fraction, or is it all of them?
I'm so sorry, my lord. The best I can do to help is that paragraph in our skeleton argument that we took instructions on what we could provide, the information we could provide that would most assist the court. I don't think there's anything beyond that. But there are, of course, appeal rights. And as I say, the appeal is being pursued in parallel. So I think I can take the other cases relatively briefly, and I hope I'll be finished before the short adjournment. The other authorities that are of relevance are Goodyear at tab 11, the short point about that case is that it was concerned with a Category 1 case, so a case where the statute provided for the giving of notice, it referred to the giving of notice, but it didn't define it, and it didn't make any supplementary provision, whether by an enabling power, wouldn't have applied anywhere here, or by defining it in the statute. So you'll see the provision that the court was concerned with at footnote 1, page 35 of the authorities bundle. In the Restrictive Trade Practices Act 1956, where goods are sold by a supplier subject to a condition as to the price at which these goods may be resold, either generally or by or to a specified class or person, that condition may, subject to the provisions of this section, be enforced by the supplier against any person not party to the sale who subsequently acquires the goods with notice of the condition, as if you'd been a party there too. You see at page 38, from the introductory words of the judgment of the Master of the Rolls, Lord Evershed, that the appeal raised a question of some importance on the meaning of section 25(1). And it's in that context that Mr. Squires relies, page 41, you'll see it's sidelined. The word notice to a lawyer, in my judgment, means something less than full knowledge. It means, no doubt, that the thing of which a man must have notice must be brought clearly to his attention. Well, the short point is this was dealing with the general approach to notice. It was dealing with a Category 1 case where no specific provision has been made, either in the primary legislation or by way of enabling secondary legislation. Stock and Frank Jones, which you have at tab 12.
Didn't you say it's not in point? We're not in
Not
that
in
category
point.
of case, so we
No.
can put that. That's your
No.
submission.
Yeah,
Just goes to one
absolutely.
side.
Not in point.
Sorry, where do you want to go next?
Next one, tab 12.
Stock.
Stock and Frank Jones. That's simply concerned with the general approach to statutory construction. Mr. Squires, I think, relies upon it to say that notice means notice, and there's no absurdity or ambiguity. But that's not the issue here, we say. The issue is the scope of the enabling power in section 41. And we're not concerned with a case where we're just applying general legal principles of what is or is not good notice. And it may be that I've misanticipated what my learned friend's going to say, and I'll come back to it in reply where I have to, if I have to, where I think it would be helpful to the court. Inco Europe at tab 13 addresses the circumstances where the court can depart from the statutory language because there's an obvious drafting error. And I don't know how this is really going to be alighted upon, because it's never been our case that there's an obvious drafting error or anything of that sort. I think what was anticipated was that we were saying that the deeming provision in the 1914 Act ought to have been carried forward, but we're not saying that. We're saying Parliament chose, rather than having a provision in primary legislation, as it did in 1914, to move to an enabling power and that way make provision for subordinate legislation to deal with the notice requirements. Anna Frieva at tab 14 is probably of more relevance, although it's in our respectful submission certainly not decisive. I don't know if the court, I know some members of the court will be familiar with it, but briefly, this was a case where a person who'd made an asylum application was entitled to income support until the Secretary of State recorded the asylum claim as having been determined. But the process that was adopted under the immigration rules was that there would be a decision on the asylum claim, and then the immigration officer would go on to consider whether there was any other basis for granting leave to enter or remain. So the asylum claim would be recorded as having been determined some time before the person was notified of it. And indeed, it appears that there was a policy or practice at the time that involved significant delay between recording the refusal and the notification. The upshot was that the person would be deprived of their income support without knowing that their asylum claim had been recorded as having been determined. The first judgment sat of Lord Bingham, and it was actually a dissenting judgment. He was in the minority. But could I just take you to one paragraph of his reasoning, because you'll see the basis on which he determined whether the recording of the refusal had effect. It's page 76, paragraph 15. Lord Bingham said this: "I would readily accept that the Home Secretary was subject to a public law duty to notify the appellant of his decision on her asylum application, and if it was adverse, his reasons for refusing it. Such an obligation is expressed explicitly in Rule 348 of the rules and would in any event be implied. But there is inevitably in a written procedure some gap between the making and notifying of a decision. Rule 348 prescribes no time limit. Any implied duty would be to give notice within a reasonable time. Failure to give notice within a reasonable time would be a breach of the Home Secretary's public law duty, but would not necessarily nullify or invalidate his decision." So that was Lord Bingham's analysis. The leading judgment of the majority was that of Lord Steyne, and that hinged upon the principle which he enunciated at paragraph 26 on page 81. Picking it up on the second line, notice of a decision is required before it can have the character of a determination with legal effect, because the individual concerned must be in a position to challenge the decision in the courts if he or she wishes to do so.
Not a technical rule.
Sorry?
Not a technical rule.
Oh no, not a technical rule. But the key point is that the court was there concerned with a provision which contained no explicit requirement to give notice at all. And the question was whether the Secretary of State was required to give notice. It wasn't an argument about what notice meant. There was no definition of notice, there were no subordinate legislation. The question was there a requirement, not how can it be satisfied?
Well, you say, I'm sorry, carry on.
Sorry, no,
No, you carry on.
But in any event, it's notable that Lord Steyne at paragraph 28 accepted, and I pick it up 6 lines before the end of the paragraph, there must be exceptions to this approach, notably in the criminal field, for example, arrests and search warrants, where notification is not possible. So it wasn't an absolute rule. And Lord Millett, who was also in the majority, formulated it this way at paragraph 43, picking it up on the second line: "The presumption that notice of a decision must be given to the person adversely affected by it before it can have legal effect is a strong one. It cannot be lightly overturned. I do not subscribe to the view that the failure to notify the appellant of the decision invalidated it, but I have come to the conclusion that it could not properly be recorded so as to deprive her of her right to income support until it was communicated to her, or at least until reasonable steps were taken to do so. So we say Anna Frieva is not about what is notice, what is good notice for the purposes of a particular statutory regime. It's about whether there is a general requirement to give notice, and we see that the court held that yes, there is an implied requirement to give notice, save in particular circumstances where it's not possible to
Well,
do
this
so.
phrase, where not reasonable, when until reasonable steps are taken to do so, that phrase, doesn't appear in the other judgments of the majority, does it?
I don't think it does, no.
Are you saying that what Lord Steyn said in 28 indicated some sort of agreement with that?
Well, I'm saying that the court wasn't saying that this was an absolute rule, that there had to be notice given and received, and that there were no exceptions.
Well,
to
there's
that.
differences there. Lord Millett is saying what he says about reasonable steps,
Yes.
whereas Lord Steyn is saying that rule doesn't apply in some circumstances at all.
No.
Obviously, you don't give people a notice you're going to arrest them.
No. But that's because the question was whether you implied into the statute a requirement to give notice as a matter of public law principle. It implied it into that particular statutory context. It wasn't a case, as we have here, where there is a clear and explicit requirement to give notice. The dispute here is about what giving notice entails.
Well, is the purpose of the notice as described by Lord Steyn at 26? What's the difference?
Right.
Well, I know one is an express statutory power and one is an implied. One is a statutory requirement for notice in this case. The other is implied.
Yes, that's absolutely right.
But is the purpose the same?
Yes, I think broadly speaking, the purpose is the same. And in that regard, it's perhaps important to observe that, as a judge observed in his judgment, it's been common ground throughout that the Secretary of State is, in the present context, under a public law duty to take reasonable steps to bring the notice to the person's attention once it's practicable to do so. The question is a slightly different one, and it is whether the scope of the deeming provision, the scope of the enabling provision in section 41 means the notice is deemed to have been given when the Secretary of State gives notice in accordance with the regulations. So it's not the same question.
Mr. Vanessa, before you leave it, can I invite you just to look at a paragraph I picked up, which is paragraph 31 of this. And what that seemed to me to suggest, so this is from Lord Steyn, is that, of course, you can have a situation where notice in relation to a fundamental right isn't required for whatever circumstance, but that's preserved to Parliament to confer that right, and it's not something you can manage by secondary legislation.
No, I think that's right, but I'm not sure that that answers the question as to whether regulations can make provision for deemed notice. And indeed, as my lady knows, Mr. Squires accepts that they can in certain circumstances.
Your case is that Parliament did.
Yes.
That's your case. And if you're wrong about that, then that's the end of your appeal, isn't it?
It is. Yes. I mean, it really is quite a short point. Either the enabling provision is wide enough to enable these regulations, or it isn't. Applying ordinary principles of statutory construction. So, the 2 points I had left to make. Firstly, and I think I've already made this, we accept that there's an implied obligation to bring the notice to the person's attention once there is a practicable means of doing so. And secondly, there is a bill making its way through Parliament at the moment. Learned Friends wanted it included in the authorities bundle, so you have it there together with an explanatory statement. It's at the explanatory statements at tab 9, and the clause of the bill is at tab 10. I don't propose to take you to it because, in my respectful submission, it can't really assist the court. That doesn't demonstrate the intention or manifest the will of Parliament. It's not been enacted. It is draft legislation.
No, but if it was enacted, it would be in your other. I've got my categories mixed up, but whichever one it is, the one that isn't our case now, it's the one that's the enabling provision.
Two.
Two.
Yes. Yeah.
Forgive me. It's a category 2 example.
Precisely, yes. So, could I just ask Mr. Deakin if there's anything I ought to have addressed in submissions that I haven't?
Can you help me just in 2 seconds to identify the passages in the judge's judgment which you say are wrong and inconsistent?
I'll do my best.
I always find appeals that are argued without much reference to the judgment rather difficult.
I'm sorry, yeah, indeed. I did one recently where there was no reference to the judge's judgment at all until I responded. I tried to avoid that.
You referred to
Half a point.
Half a point again. Yes.
referred to 44 and 45.
So we're in 41 already, 41 onwards.
The judgment, I think.
Yes.
Yeah.
Paragraph 41.
Oh, sorry, I was looking at page numbers.
I mean, you referred to his 4th and 5th reasons,
Yes.
but I just be useful.
Oh, do you know, I'm so sorry. I think because there's a certain amount of discussion, what I never did was take you to the facts. But you have the facts insofar as they're relevant and a common ground, set out at paragraphs 5 to 11 of the judge's judgment, and there's no dispute about those. So the errors, well, I don't propose to depart from our Scalish arguments, so could I just adopt all of that? But in terms of clarifying or enlarging upon that, we think the key error is at paragraph 45, where the judge concludes that Parliament didn't confer a power.
The last sentence of 45 is where you say the judge went wrong, isn't it?
Yes, he accepts that Parliament can and sometimes does confer power to make regulations creating a deeming provision, but that says that it didn't do so in this case. We say if you just look at the plain words of the enabling provision, it is a really broad enabling provision, and it's just subject to the ordinary restrictions of.
Do you say that his
advancing
case,
statutory
the judgment, if he's wrong about that, the whole judgment falls away?
Yes, I do.
I mean, your argument is if section 13.2 works, then by some sort of analogy of reasoning, so does section 41.1 works.
Yes, I mean, I say yes. I say section 13.2 is just another example.
Another example, same thing.
Yes, and the fact that Parliament said in particular.
And they happen to get the word deeming into the in particular phrase,
Yes.
but you say that's neither here nor there.
No.
So you've got to step back a bit further and take a bigger view.
Yes. I mean, that's our key point. I mean, our Scalish argument does, I think, make 5 or 6
More elegant than that,
criticisms,
yes.
much more elegantly than it has James Eadie's name at the top of the list. But this is the key paragraph where the judge, we say, fell into error.
Thank you very much.
Unless I can assist you further. Thank you very much.
Yes, Mr. Squires. 10 minutes to poison our minds.
Well, also, I hope I can just start with some things that aren't in dispute. And they particularly arose actually from the start of Ms. Giovanetti's submission. And the first is that it's the order under 42 that deprives a person of their citizenship. So the decision under 45 has no legal effect, save that it triggers the right to appeal. But unless and until an order is made under Section 42, an individual remains a British citizen. There was some suggestion in Ms Giovanetti's submissions that the order has to follow from the decision. And that is important, or it's important to see that that is incorrect, and that was a point made by the learned judge, or a decision made by the learned judge about remedy below that wasn't accepted and hasn't been appealed. Because one of the things that was said below is, well, there's no point in quashing the order because the decision still stands and the Secretary of State could then simply make the order again. That was rejected. It's paragraphs 52 to 67 of the judgment.
It's true but irrelevant. It's true the Secretary of State can make the order again, but they have to do it, she has to do it properly if she's going to.
Precisely, and in particular, she has to make a decision as of the current date. And so, again, this was all argued below. There is now, it's said on D4's behalf, evidence that she was trafficked that wasn't before the Secretary of State when she made the initial decision back in 2018. So it matters to her that the order has been quashed, even if the decision hasn't been, because what she'll want to go back is to say, well, hold on a moment, now you have this additional information, do not make the order. So, again, so that's not in dispute at this level, that it does not necessarily follow that because a decision was made, the order will be. It matters to this individual that the order, at least currently, albeit stayed, has been quashed. Thirdly, it's not now disputed that the giving of notice, it's not now disputed that if notice is not properly given under Section 45, it's not disputed that the order will be a nullity. That's the condition precedent point for which permission was refused. So the Secretary of State initially brought two grounds of appeal. Second was a condition precedent point, and that was refused by Lady Justice Davis. So it is now not in dispute before this court that if proper notice is not given under Section 45, the deprivation order is a nullity. Turning to what is in dispute, as the courts will be well aware, the case turns on a narrow point of statutory construction, which is the correct interpretation of Section 45, read with Section 41, and in particular 41(1)(e). Section 45, again, but we'll turn to them, I will turn to them, I think, probably just before lunch, but 45, unequivocal obligation, before a deprivation was made, the Secretary of State must give a person written notice, Section 45. Then 41, and particularly 41(e), make provision generally for carrying into effect the purpose of this Act, and in particular for the giving of any notice required to be given to any person. And the issue on appeal is whether Regulation 10.4, as amended, is intra vires Section 41, in particular 41(e).
But are there not many provisions, statutory provisions, that say notice must be given, and then provisions for deeming or situations that are actually situations where notice is not received?
I'll come on to those, because partly I think we do need to look with some care at the learned judge's decision, because I think there was some suggested criticism that he took a sort of all or nothing approach. He didn't, we say. What the position, our case is this: what you cannot do, if Parliament has required notice to be given, is by regulation to allow notice not to be given. You cannot remove the requirement in Section 45 by regulations. And we'll come on to there are other kinds of deeming.
I mean, why is that? Because notice is not a binary issue. I mean, that assumes that notice always involves receipt.
My Lord, and I'll take to the authorities. We say that is absolutely clear from the authorities. Notice involves, we say receipt. What you
Not
can,
in practice.
well, so what you can have deeming provisions, and I might end up slightly out of kilter here, but for example, Regulation 10.5 of the regulations is a deeming provision, but it is a rebuttable deeming provision.
Yeah.
So that does not remove a requirement to give notice. It says it will be deemed to be given unless the contrary can be proven. But our submission is, I will certainly take this point when I get to it, is that if you have a statutory provision that requires the giving of notice in primary legislation, it is not, we say, lawful in regulations to make provision dispensing with the giving of notice.
Your case doesn't turn on receipt. Your case is there wasn't the giving of notice.
Precisely, and I'll come on to that because this is a point that the learned judge below left open in paragraph 46. He said it is strongly arguable, this is paragraph 46, that giving notice requires receipt.
That's the distinction between last known address, leaving at the bottom of the stairs, giving to a neighbour. That's an act of giving, but filing the drawer isn't an act of
Precisely.
giving.
So what?
That's your main point. It doesn't turn on receipt.
Yes, what the learned judge said below is, he said, well look, I think it's strongly arguable that giving notice requires receipt. A person is not given notice unless they've received it. But, he said, he didn't need to determine that because, he said, on no analysis, on no statutory construction can this be, and putting something in a drawer, knowing it will not be received, be the giving of notice. We say that in order to succeed in this appeal, the Secretary of State needs to show one of three things, or one of three ways of reading the legislation. And I think from hearing my own friend's submissions, it's the third and possibly the second that she pins her colours to. The first thing one way she could succeed is to read words into section 45. I say it currently states, before making a deprivation in order in respect of a person, the Secretary of State must give the person written notice, specifying things. Now, one option would be to say, well, you can read into that, must give written notice, save if it is not reasonably practicable.
Well, she didn't say
She
that.
doesn't say that. That would clearly require a drafting error. She doesn't take issue with section 45 being a mandatory requirement to give written notice. Second, the Secretary of State could seek to show that as a matter of ordinary construction, the requirement to give a person written notice can be satisfied by placing a notice on an internal file. As in, you're reading section 45 says, must give written notice. She could argue, well, here, placing the notice in the file was the giving of written notice, as required by section 45. Now, I wasn't sure if that was being argued. We say that is clearly wrong. That's dealt with paragraph 49 by Mr. Justice Chamberlain. He says, as a matter of ordinary language, you do not give someone notice of something by putting notice in your desk drawer and locking it. No one who understands English would regard the purely deprived act as a way of giving notice. And we say, again, as a matter of statutory construction, that must be right. If person A is required to give person B written notice, person A thinks it is not practicable for me to give notice, so I will put it on a file. Person A has thereby given written notice. That simply cannot be, on any analysis, what a requirement to give written notice means. And again, we do say that is fatal to the Secretary of State's case because the requirement in 45 is must give written notice, and this plainly wasn't. I think at some points that appeared to be accepted by Ms. Giovanetti, at others not. The third, and this is where we understood the mast, which we understood most of the colours were being nailed to, if that is not the most uncomfortable analogy. It was this, is the Secretary of State would have to show that even if placing a notice on a file is not the giving of notice, that the Secretary of State is permitted to make regulations under 41, in particular 41(1)(e). 41(1)(e) says the Secretary of State may make regulations in particular for the giving of any notice required to be given to any person under this Act. One would have to read that as allowing or including regulations dispensing with the requirement to give notice.
Well, I don't think that's what she says at all. I mean, we can come to it after lunch, but I think what she says is that the general power to give effect to the purpose of the legislation is all about the purpose of removing people's citizenship fairly and appropriately. Notice is not a purpose of the legislation, it's a provision of the legislation. And in order to make it work, sometimes you have to have provisions that dispense with service in this way. And your point is, well, that's directly contrary to Section 45, and her point is, well, it doesn't matter because I've been given a power to derogate from it.
Well, but our response to that is twofold. The first is what the Secretary of State, that the general, if one starts with the general under 41, is to make provisions generally for carrying into effect the purposes of this Act. And I think it was accepted by Ms Giovanetti's that the purposes of the Act is to allow Parliament fairly and effectively to remove citizenship in appropriate cases. So not Parliament. Parliament has decided the purpose is to allow the Secretary of State fairly and effectively to remove citizenship. It was I think, what she accepted. But Parliament has, and we'll come back to this when we'll look at Section 45, made legislation as to what fairness requires in this context. It could not be more explicit in Section 45 in stating, that's why I went to the argument that wasn't being pursued. It did not add in the words, unless reasonably practical. Parliament has decided what is required in order to remove citizenship in this context, and it's in Section 45. So one cannot say, well, when Parliament says purposes generally for the very, very general provision, what Parliament meant there, having said what is required for fair removal of citizenship, must give written notice, but that could be removed. And the second point leading on to that, from that is, of course, 41(1)(e) is the specific, when Parliament is then specific about the regulations in relation to notice. And again, those, we say, could not be clearer. Giving of notice required or authorised to be given under this Act. That, again, cannot be read as saying, dispensing with the requirement that we, Parliament, have decided in Section 45. And
that might be a good moment to break, mightn't it, Mrs. Squires?
yeah, it's my voice. Yes, certainly.
2 o'clock.
Court rise.